Can non-consummation invalidate a marriage? Imagine tying the knot and wondering if your marriage can be considered valid without ever sharing a night together. It might sound unusual, but in family law, this question has real answers. When a couple gets married, many believe that physical intimacy is a key part of making the marriage valid. Consummation means having sexual intercourse after the wedding. In some legal systems, this act is seen as an important step to show the marriage is complete. But what happens if the couple never consummates the marriage? Can that make the marriage invalid? In some places, non-consummation can be a reason to annul a marriage. Annulment is a legal process that declares a marriage never truly existed. But it's not automatic. Usually the law requires specific reasons, like one spouse being unable to have sex because of a health issue that was not known before the marriage. This is called physical incapacity. If one spouse refuses to have sex without a valid reason, that might also be grounds for annulment, but it depends on local laws. Different states and countries have different rules. For example, in New York, annulment for non-consummation is only possible if one spouse has an incurable physical problem that prevents sex and the other spouse did not know about it when they married. The request must be made within 5 years of marriage. In California, if the marriage was never consummated because of physical inability or refusal, it can be grounds for annulment. In England and Wales, refusal or inability to consummate can be a reason for annulment if the marriage is between opposite-sex partners. However, non-consummation does not count as a reason for annulment in same-sex marriages there. To get an annulment based on non-consummation, proof is often needed. Medical reports showing incapacity or evidence of refusal are common. The person asking for the annulment must usually act within a certain time frame. If the marriage is annulled because of non-consummation, it can affect property rights, support, and whether children are considered legitimate. If both spouses agree not to consummate the marriage, or it's due to emotional or psychological reasons without physical incapacity, courts are less likely to grant annulment. So, to answer simply, yes, non-consummation can make a marriage invalid through annulment, but only if specific conditions are met. These include physical incapacity or willful refusal, and the rules vary depending on where you live. Always remember, proof and timely action are important in these cases.